thank you so much for being here. My name is Barb Van Hoy, and I am a policy analyst with the Community Development Division at the City of Colorado Springs. And it's my pleasure to welcome you to the first Renter Rights 101 workshop of our community collaboration for free. We are fortunate to work with a great group of community advocates and organizations that are helping to put this event together. And that includes Colorado Legal Services, Pikes Peak Library District, the Justice Center, Colorado Housing Connects, which is a project of Brothers Redevelopment. And we're so excited to be welcoming new collaborators, including the Independent Center. Thank you so much for hosting us, Deanna. And then also the Area Agency on Aging, although none of their staff people could be here today. For those of you who are here in person, if you haven't yet, check out the great resources that are on the back table around from all of our partners, information that will help that is related to renter rights and information. So tonight, the main event is going to be the attorney from Colorado Legal Services, who's going to go through lots of great detail about leases, about reasonable accommodations and modifications, deposits, repairs, eviction. But before we get into that, we get to hear very briefly from each of our partner organizations. We're going to talk about what kinds of resources you can access through their websites or through their organizations and how to get in touch with that. So I think I will introduce first, if it works, Deb Hamilton, who is the law librarian from the Pikes Peak Library District, who has also published a book. Thanks, Deb. Did you go to the show website? Oh, yeah.
Hi everyone, my name is Deb Hamilton. As Barb said, I work for the Pikes Peak Library District. I'm the law librarian there. So we have a legal research collection that's located at our downtown branch, the Penrose Library. There you can find lots of different legal materials, and we also have a lot of online resources here as well, which we're going to pull up in just a second. And so if you go to our main website, ppld.org, when you get onto that main page, you'll see a tab for research. You'll click there, and then you'll see a link for the law collection, and that will take you to this page. On here, you can find my contact information, so feel free to reach out if you have follow-up questions. I can always point you in the right direction of where to go. And then if you keep scrolling down on this main page, you'll find a lot of the resources that we're talking about today. So information about the Justice Center, which you'll hear more from. There's this eviction diversion mediation program that we also have flyers for in the back. So there's some good information about that as well. And then Colorado Legal Services, where Clinton works, there's their contact information as well. Clinton will talk a little bit about what's in the Colorado revised statutes. So those are the state laws for Colorado. So you can view them all online here, but we do have them in print at both the Penrose Library as well as the East Library. And then the Colorado Springs City Code is also available right here. Our library system, we also do a monthly legal clinic. Flyers are for that are in the back, but it's also down here at the very bottom of this page. So that's going to be the first Monday of every month from 3:30 to 5 at the Fountain Library location. We also, if you do need to do a remote court appearance, we do have virtual courtrooms at some of our library locations. Again, there's a flyer for that in the back as well. And so if you need help getting signed up with one of those or accessing a virtual courtroom, I can kind of walk you through some of that stuff as well. So I don't want to take up too much of your time. Just kind of remember, if you need to get in touch or you forget anything you hear here, I'm always a good point of contact to connect you with stuff in the community. Cards are also in the back too if you like something cheaper. So thank you all for being here, and I'll hand it back over to Barb.
Thanks, Deb. And also, for those of you both online and who are in person, we will be sending out these slides that also have links to all of these resources as well. And we'll be posting those links in the chat for the Zoom as well. Thank you, Deb. Next is Laura McKiernan, who is the Executive Director of the Justice Center.
Thank you so much. My name is Laura McKernan. I am the Executive Director of the Justice Center. Let me just guide you to. That is our website. It is www.justicecentercos.org. We are a 501c3 nonprofit, and we have 3 different programs that can help you, especially with the challenges that you are going through as renters. The first one is something we call Ask a Lawyer. You can call in every Wednesday from 7 to 8:30. All the information is on the website of the number you can call. We first screen your call. A human screener will then answer the phone and ask you, tell me a little bit more about your case so that I can direct you to the correct attorney. And after that, you get put on hold and they'll tell you your number 1, your number 7. Last Wednesday, we had number 27 on the wait list. So sometimes it gets a little bit difficult, but you will get your answer from a Colorado barred attorney who can answer your question, be it in landlord tenant or in other different areas of the law. The second program we have, and within Ask a Lawyer, we also have Email a Lawyer in case we don't have a landlord tenant attorney that evening. Sometimes that does happen, rarely, but sometimes it does. And then you can email us, and that you can find on our website by clicking Ask a Lawyer. It'll direct you to Email a Lawyer. You fill it out, you tell us what's happening, and a lawyer will get back to you within 7 business days as to forms you might need, a place you might need to go, something you might need to fill out so you can get your answer.
Yes, to see you online.
So sorry. I'll stay here. I'll stay here. Thank you. After Ask a Lawyer, we have something called Find a Lawyer, and that's when you actually have a legal case that you need an attorney for. Sometimes we can't afford attorneys. I know that's a thing. So you can come to us and apply and tell us what is happening and what type of attorney you might need, and we'll try to pair you for free or for a reduced fee with an attorney to take your case. And our third program is something we like to call Learn with Lawyers. And Learn with Lawyers, we have videos on our YouTube channel about different types of necessities that we found in the community. Something like, what is a service animal? What is an emotional support animal? How can I get them to live with me? Do I need to pay a fee if they're in my house? Things like that that you might have questions about. We have different videos that you can go online and take a look at different answers that attorneys in our community have. So thank you for having me, and I hope that we can help you.
Thank you, Laura. All right, next is Katrina Bell, who is with Colorado Housing Connects, and she is a housing counselor. You see your tab?
Yes, I found it. Okay. My name is Katrina Bell, and I am with Colorado Housing Connects. We are owned by Brothers Redevelopment, and we run a hotline that answers all types of housing questions for homeowners, renters, home buyers, landlords, and some of the things that we'll be talking about tonight. We will answer questions for. If you have a tenant landlord issue, we'll answer questions about your landlord coming into your house. They had a lady that said her landlord comes in and cleans her bathroom. That's not weird at all. She's like, is that okay? No. I legally and just weird, no, I don't think it is. And so we answer questions for renters that call us. Our hotline is open from 7:30 to 4:30 every day, and people will call and ask questions. We also help homeowners and home buyers find houses. We help with CHAPA and different ways to finance homes. We also talk with landlords about things that tenants are doing. Tenants never do anything, so we don't talk to many landlords. That's not true. So we talk to landlords, and we also have a I'm sorry, I just completely lost all the words. We have a thing called home modification and repair, where people need roofs on their houses, or they need ramps, or they're aging and they need things to continue to age in their home. So you can give us a call, and our home modification and repair will come and assess your roof or assess the things that you need or your parent needs to continue to age in their home. We also do a paint-a-thon, where we will pick a block and have volunteers over the summer and come and paint your block. So if you have a block that needs to be painted, contact us and we'd be happy to come out and paint the houses that are on the block. We also, again, back to renters, we help renters fill out warranties of habitability and different things that are needed, and just answer questions. And we work closely with all of the organizations that are represented here today. So our hotline is always open, and you're welcome to give us a call at the 844 number, and we'll answer any questions that you have. Birthday, guys.
Thank you, Katrina. And then next, I'm happy to introduce Diana Runzi, and she is an organizer with the Independence Center. She's going to talk about those facilities.
Good evening, everyone. So welcome to the Independence Center. Thank you so much for joining us in our lovely space. We are a Center for Independent Living. There are over 400 in the United States. We offer lots of different core services, advocacy, information and referral. You don't have to necessarily have a disability on paper to be able to access our resources. You just have to identify as somebody who has a disability, which is a very broad category. We also offer housing. We hold over 600 housing vouchers. Again, you don't necessarily have to have a disability to be connected with us in our housing voucher and get support for those kinds of pieces. We have a veterans directed care program. We've got lots of different programs around independent living. So thank you so much, and welcome to the Independence Center.
Thank you, Diana. I forgot to say that. It's on our website up here, and that will be in the list of links that we send out to folks. Brent Wiener, who is an attorney with a mediation program, is not here today, but information about that program also will be part of what we send out. And then the Community Development Division at the City of Colorado Springs provides resources. Probably one of the best ones related to tonight's is our emergency housing resources page. And we keep that pretty well updated with different resources, organizations, including all of those that are here, for eviction prevention, rental assistance that is available, other information. We also have information for homeowners and landlords and utility assistance as well. The Community Development Division at the City of Colorado Springs manages the city's grants through the U.S. Department of Housing and Urban Development. And so those funds are invested in our community in affordable housing, in accessible facilities and neighborhoods, local neighborhood economic development, homelessness response and prevention, and other services for low and moderate income residents. And we help to support this workshop because as a recipient of HUD funds, it's our responsibility to help further fair housing, and so that is part of what we do here. Reducing conflict between tenants and landlords, and really just helping to promote housing stability of the residents of Colorado Springs. So that's it for all of the introductions and different resources. Again, we'll be sending all of that out. We are recording this, and we will be sharing the recording with everyone who is registered, or if you sign up for the newsletter for the Community Development Division, you can sign up for that newsletter on the sheet on the back table. And so now it's my honor to introduce the housing attorney with Colorado Legal Services, Clinton Albert. He has served for 4 years, or is it more now?
It's
Almost 5. His caseload is made up solely of landlord-tenant matters and covers a broad range of legal issues in that area. And he's going to school us. Thank you so much for being here, Clinton, and please join me in welcoming Clinton. That one.
All right. Evening, folks. My name is Clinton Albert. I'm an attorney with Colorado Legal Services, and this evening we're going to be discussing renter rights. This presentation is going to cover a broad range of subjects, and I will open this up for questions at the end. So just keep those questions in mind as we're moving through things, because there will be a Q&A at the end. All right, so just a few things to keep in mind as we lead off this evening. This presentation is for informational purposes only. This does not constitute legal advice because housing issues and cases, they all require a thoughtful analysis of both the facts and law that may apply to your case. Also, if you want to speak to an attorney about that, it's better done with some sense of privacy and confidentiality, and this room would not be the best forum for a one-on-one conversation about an individual matter. But if you are facing a housing issue, you may contact Colorado Legal Services at 719-471-0380 or in person at our new office location at 102 South Tejon Street, Suite 430. That's at the corner of Tejon and Colorado. So some things to keep in mind before you move into your new residence. And this is not everything, but just a few things that I think are important as you're starting off in your new home and your new journey. First is put everything in writing. Even if you have a handshake deal going into it, follow up that verbal agreement with something in writing laying out the terms. I think this is the best practice for both tenants and landlords. Oral leases, they are valid, but it is more difficult, if not impossible, to prove a specific term or a specific condition of an oral lease. Those are presumed to be month-to-month leases. You cannot have a lifetime oral lease. So if there's some kind of arrangement where you're being told, you can stay here as long as you want, that needs to be put in writing because that's not an enforceable term. So it is my opinion that the best practice for both the landlords and the tenants is to put your rental agreement into writing. But before we get to that lease itself, the first step in kind of an apartment seeking process is going to be applying for one. And there are rules that apply to the application process itself. Landlords are not allowed to charge an application fee unless the landlord uses the entire amount of that fee to cover the costs for processing the application. Costs may be the actual expenses it takes, or if you're kind of doing a batch of applications, the average expense of an application. Landlords are not able to charge different application amounts to different applicants. And a landlord must provide an applicant with a written disclosure for what the anticipated or actual expenses are going to be to process the application and a receipt for any fee paid. If there's any amount remaining, so if for some reason that calculation was off and there's some kind of remainder, landlords are required to make a good faith effort to return remaining amounts of the fee or fees to the applicant or applicants. So that's just the application fee, but in the application itself, there's going to be presumably there'll be some kind of background check for credit history, rental history, criminal history, or some combination of the three. So for rental and credit history, a landlord can only take into consideration the last 7 years of your rental and credit history. There is no consideration for any history older than that. So if you were evicted 8 years ago, not a reason to deny an application. If you filed for bankruptcy 10 years ago, not a reason to deny an application. But if you were evicted 6 years and 11 months ago, that would still be a reason to deny an application. 6 weeks later, it would not be. What about criminal history? For an arrest record, that can never be considered. That can never be a reason to deny an application. You could be arrested 100 times. If you have 0 convictions, 0 reasons to deny an application. As far as criminal convictions, no convictions older than 5 years, except methamphetamine-related offenses generally, offenses that require a person to register as a sex offender pursuant to Colorado statute, homicide-related offenses, and stalking. So regardless of the age of this group right here, these convictions can always be used to deny an application. One exception here, just as a note, when I say methamphetamine-related offenses generally, that does not include simple possession. So what happens, you paid the application fee, you've submitted the application, and your application is going to be denied. So you're entitled, you have a right to a written notice of the application denial. In that written notice, it must include the reasons for the denial of your application. And that's how we can confirm that, well, they didn't consider my 10-year-old conviction for DUI. They didn't consider my bankruptcy from 15 years ago as a reason for it, because it has to be put in writing why it is that your application is being denied. And also then, in addition to providing that writing, this isn't something that maybe you'll find out at some time in the future at a date to be determined. The landlord shall make good faith efforts to provide you with this written notice, this written denial decision within 20 calendar days of the decision to deny the application. So on the application itself, make sure that you're including good contact information, a mailing address, an email address, some way that the landlord can communicate with you if they choose to deny the application. Because if the landlord does not follow the law, you as an applicant have recourse to that. So if you don't get a written denial, if the denial is for reasons that are outside of the law, if we're talking about different amounts of fees being charged or not being given, not having any remaining fee returned to you, as an applicant, you can seek as damages 3 times the amount of the application fee itself, plus court costs, and you can also seek reasonable attorney fees if you're represented by an attorney and you file this action against the prospective landlord. Before getting into that kind of lawsuit, though, as the wrongfully denied applicant, you have to provide the landlord with a 7-day demand letter stating your dispute with the decision to deny, and that gives the landlord 7 days to cure the wrongful denial, or if we're talking about maybe some kind of mischarging of the rental fee, to provide that feedback to you. So what that means is within that period, that 7-day period of time, the landlord can fix the problem. They can cure the alleged violation of the Rental Application Fairness Act. If a denied applicant brings a suit and that suit is meritless, so let's say the reason for the denial is very clearly you were convicted of drug distribution last year. Well, that's a meritless claim. That's a conviction that can be considered. So unless there's some kind of unequal treatment that you can show, it's likely a meritless claim. And in that situation, you may be liable for the landlord's court costs and the landlord's attorney fees if you bring a meritless claim. And down here at the bottom, there's the statutes which cover the Rental Application Fairness Act. So the application is approved. You now have a lease in front of you, and it's 50 pages long or 100 pages long. Guess what? You've got 50 pages to read, or you've got 100 pages to read. You have to read every single word, every single sentence of every single page. Because when you put your signature on it, you said, I read it, I agree with it. It is not valid to come back in time and say, well, I didn't read my lease. This is a business relationship. So if you are entering into a business agreement, which is what that contract is, read what you're signing. This is also really important to potentially avoid problems down the line. So again, no matter how long this is, if you have to take the lease home and read it over home, do that. Don't feel that you need to sign this within 3 minutes because you could make a mistake that will follow you for months or years if you do that. So what are some things to take a look at in the lease? Well, first of all, what's the lease term? Are we signing a 1-year lease, a 6-month, 9-month, week to week, month to month, day to day? You want to know what that term is. What happens at the end of the lease term? Does it just end? Does it automatically renew on the same amount of time? Do you have to have some kind of written agreement to extend it? That's going to be important because if it just says this lease is over after the 12 months, after the 6 month, after the 1 month, you've got to plan accordingly. For, hey, I need to make plans. I need to start budgeting ahead when it gets to that end of my lease because I have no promise of being able to live here any longer. You can certainly reach out to your landlord and have a conversation about a renewal or an extension. But if you're being told no and you don't have any kind of automatic extension in your lease, please plan accordingly for that. What are potential fees that may be associated with the tenancy? And we'll touch this later, but one of the big ones is going to be late fees. What about any kind of responsibilities for upkeep, for maintenance? Are you in a single family home and you have to do yard work yourself? Is there some common area, maybe in a fourplex that requires all of the tenants, all of you and your neighbors to kind of pitch in to keep it clean? Just make sure that you're checking out any other responsibilities that you may have beyond paying your rent and making sure that you report any kind of warranty of habitability issues. Also, where should you send notices? I just mentioned the warranty of habitability. What if you have that issue? Where are you going to send that notice? Because you want to know, one, to make sure that you're living in a habitable residence, but also as a landlord, you want to provide that address because if you have a problem with the property, you want your tenants to be able to notify you as soon as possible. Because otherwise that problem's getting worse and that's on you. So again, this is a big one too. Those were some specific sections, but also if there are rules and regulations, if your lease agreement refers to house rules, regulations, you want to make sure that you have a copy of that. Those are additional conditions of your tenancy. So if you see that reference in the lease of see rules and regulations addendum, see addendum rehousing rules, something like that, but you don't see that actual writing, make sure that you either cross that out and you both sign it, or you get a copy of it. Because if you agree to something and you don't have a copy of it in writing, what'd you agree to? And landlords, if you don't provide that, if you have these rules and regulations, make sure you provide it to the tenant because you can't come back later and say, well, you violated these rules that I didn't tell you about. That's just inherently unfair in this situation. You may receive a copy with your lease. So again, it's important to know what these conditions of your tenancy are. As a tenant, what is expected of me while I am living in this residence? Other sections to review, like I said, the notice related section. Also, anything that regards an exempt residential agreement, or the warranty of habitability, which appliances are included in the lease, and an email address, portal address for an electronic notice delivery. So what's an exempt residential agreement? Very, very briefly, long story short, an exempt residential agreement provides a tenant with 5 days to cure a violation instead of 10 days to cure a violation. Notice must be provided in the written lease that the 10-day notice period does not apply to the tenancy. So there's no verbal lease that can be an exempt residential agreement. These only apply to single-family homes. So this is not an apartment. This is not a fourplex. This is not a duplex. And it only applies to a single-family home that is leased by a landlord who owns 5 or fewer single-family rental homes. If you're confused about if this situation applies to you, please contact CLS or Justice Center or the Ask a Lawyer just to kind of get a sense on, hey, is that what my lease means here? This doesn't come up very often, but if you find yourself considering, if you're signing a lease agreement and there is an option to purchase, it is the best practice to exert additional consideration on this, be extra careful with this before entering into a entering into an option to purchase agreement, I would strongly suggest seeking legal counsel prior to entering this agreement. Why is that? Because oftentimes option to purchases are a large financial commitment for you as a tenant, and you want to ensure that one, that if you're making this large financial commitment, that there is maybe some kind of mechanism to protect you building and keeping equity in the home. So just make sure that you have a clear understanding about what is my option to purchase here. Is it automatic? Do I have to take extra actions? Do I have certain kind of deadlines to make payments by? Because unfortunately, you could make a large financial commitment to a home, but if certain actions aren't taken in accordance with the lease, then you may lose your option to purchase the home and lose the money that you put into it. So as you're reading through the lease, there are some provisions which, even if you sign the lease, it's just not going to be enforceable. These are just lease contract. These are provisions or rights that can't be waived. They can't be upheld by courts. So as a tenant, you cannot waive your right to the return of the security deposit. That doesn't mean you have an absolute right to it all being returned to you, but you cannot waive your right to it being returned. You cannot waive your right to the protections of the warranty of habitability. There is an exception to this, but that exception must be in a separate written agreement. So in the lease agreement, it can't say maintenance, as a tenant, you're responsible for all the electrical work in the home. Nope, that's not going to be enforceable. One, it's a waiver of the warranty of habitability, and two, it doesn't meet any of the requirements for an exception. But there must be a separate written agreement for you to waive any portions of the warranty of habitability. You can't waive your right to the covenant of quiet enjoyment. Just kind of boiling that down, the covenant of quiet enjoyment stands for the proposition that you are able to enjoy your residence as a residence. So you're able to enjoy the leased property for the purpose of which it was leased. You're able to live in your home as a home. You cannot waive your right to a 5 or 10 day written demand for unpaid rent. You can't waive your right to a court process for a forcible entry and detainer action or an eviction. So you have a right to a court process. You also cannot, any paragraph with late fees that are not in compliance with the law, those are void and unenforceable. And we'll get to late fees more in a few slides. Other lease provisions that cannot be enforced include any kind of paragraph which imposes an unreasonable liquidated damages that assigns a cost stemming from an eviction notice or action. If you ask me what that is, it's going to depend. And that's going to be a little bit of a case-by-case analysis on if something amounts to an unreasonable liquidated damage. A lease can also not include a one-way fee shifting clause that awards attorney fees and court costs only to one party. Any fee shifting clause must award attorney fees to the prevailing party. The prevailing party is, for eviction purposes, that would be the person who has the right to possess the residence. So if at the end of a case, the landlord prevails, they would be the prevailing party. If the tenant wins, they're the prevailing party. So we've gotten through the lease. We've made sure there are no unenforceable lease provisions. We understand the terms, we understand the fees, we have a good understanding, we've signed it, get a copy. Make sure you have a copy. Because that way, in future disputes, you can look back, get a copy of it. All right. Also, it's required by the law. Landlords have an obligation and a duty to provide you as a tenant a copy of your lease within 7 days of you signing the lease. So you entered into this lease agreement with your landlord, you're living in the home, and at some point your landlord changes or the building goes up for sale and you're concerned about your tenancy. If your landlord changes, but ownership remains the same, so it's a different property management company, the new landlord must provide you with updated contact information to include new address or addresses for notice or notices. So going back to that warranty of habitability notice, if you have a new landlord coming in saying, hey, we're going to be managing the property from here on out, they do have to provide you with that contact information. And again, landlords, it's best practice to provide that, because if there is an issue, you want to know about it as soon as possible. That way, what starts out as a leak doesn't turn into a waterfall on the third floor. If you do not get this contact information, from the new landlord. Contact them, ask them, hey, where do I send notices? My lease says this, but is that still the proper procedure moving forward? Do that in writing, because again, put everything in writing. That way, if you get a written response, you can say, well, I sent my notice to this address like you told me to. So very briefly, if your building is for sale and your tenancy is jeopardized, you can record your lease with the clerk and recorder, but I would consult legal advice prior to doing so. You're recording your just very briefly, what you're doing is you're recording your property, your possessory interest in the property, and it will put any buyer on notice that you have a lease. And it would require a new buyer to honor your lease for that term if you record it prior to the new purchaser recording their deed. If that doesn't make sense, that's exactly why I think you should seek legal advice if you find yourself in that situation. If there's no current lease, then you may want to contact the new owner or the new potential owner of the building to propose a new rental agreement. So what about we're in the tenancy, paid our security deposit and first month's rent, get a receipt, and you have a right to a receipt. If you pay in person with cash or money order, you have a right to an immediate receipt. If you pay by mail with cash or money order and you have to request a receipt, and then you have a right to a receipt within 7 days. It's limited to cash or money orders. If you think about that, if you pay with a personal check, you're going to have a paper trail from your bank showing when that check is cashed. And also, you are able to include receipts in a monthly statement, but I would recommend seeking counsel to make sure that the receipts you're providing are valid.
It's not like online portals where the payment is just going to be electronic.
Probably does not apply to portals because you're going to have that electronic record from your bank showing withdrawal made on this date to this account, so you'll be able to create the payment.
So even if I don't have it from the portal, I still have it.
You have it in your bank.
That's right.
All right.
Thank you.
Another question?
Sure.
So on a hand-to-hand cash payment, then is a text message a receipt? Or is an email a receipt that you do right at the moment?
That question's never been posed to me. I would say that's sufficient. You could jot something down on a Post-it note too, but I would typically say have a carbon copy of said Post-it note so you have a copy for your own records. But I think if you have some kind of, I think that would be sufficient in that situation. And then a text message and then following up with maybe something on, some kind of carbon copy receipt would be best practice, just to make sure you're covering your butt as well on that. And also keeps your records consistent. All right, next thing here, moving from receipts, let's talk about rent increases. There have been changes to this, to the law within the last couple of years regarding rent increases. Specifically, landlords are not able to increase the rent more than one time in any 12-month period of consecutive occupancy. That's it. It's regardless of whether there's a written rental agreement. It is regardless of the length of the tenancy. It's for just once in 12 months. That's it, right? It also has to be, it can only be increased upon 60 days rent. And landlords, you cannot terminate a residential tenancy with no written agreement by serving a notice to quit with the primary purpose of increasing the rent with less than 60 days notice. In my opinion, what that means is you cannot provide a 21-day notice to quit to a month-to-month tenant and say, hey, here's your notice to quit, or you can pay me a 50% increase and we'll continue the tenancy, because you're literally doing what that says you can't, which is giving a notice to quit to try to circumvent the rent increase statute.
And
Yes.
the notice to quit is an eviction, right?
No, the notice to quit is a document from the landlord indicating that the tenancy will terminate. An eviction is a judgment for possession that occurs in a court of law. Evictions happen in court. And it doesn't happen just because you got a piece of paper. It happens because a judge ruled in favor of your landlord and entered a judgment for possession in your landlord's favor. or you entered into some kind of settlement agreement following the filing of a complaint and the terms of the agreement call for the entry of a judgment for possession. Simply receiving a notice to quit for repeat violation, notice to quit for substantial violation, or demand for compliance does not mean that you are evicted. Late fees. There's been a lot of changes to late fees recently, so here are the things that are no longer allowed. You cannot be charged a late fee unless the rent payment is late by at least 7 calendar days. And also your lease agreement must state when the rent is due for purposes of that 7-day calendar day calculation. You cannot be charged a late fee that exceeds $50 or 5% of the amount of past due rent. Not just the amount of rent due, but the amount of past due rent. If you've accepted a partial payment as a landlord, that will affect what the 50 or what the 5% would be. You cannot be required to pay a late fee unless that late fee is disclosed in the rental agreement. That's why it's so critical to read what you're signing up for. You cannot be evicted for non-payment of late fees. You cannot be evicted in a mobile home park for non-payment of late fees. You cannot be charged a late fee because your housing subsidy provider has paid major payment late. If you receive a voucher from the Independence Center and for whatever reason that voucher is late, you cannot be charged a late fee for that. And you cannot charge a late fee more than once for the late payment. So if January rent was late, January rent is still late in February, you cannot recharge it in February. You get one late fee, $50 or 5%. That's it. You cannot be required to pay interest on a late fee. You cannot be charged a late fee unless your landlord provides you written notice of the late fee being charged within 180 days after the date upon which the rent payment was due. And a lease provision that does not comply with this statute, it's void and it's unenforceable. And the tenant can bring injunctive relief, meaning filing a lawsuit to get the court to say stop it. Or a tenant could file a lawsuit against the landlord. And just by statute, landlords may be liable for $50 for each violation. And if you provide, as a tenant, if you're wrongfully being charged late fees in violation of this statute, and you provide your landlord with a demand letter stating you have 7 days to fix this, this is not permitted by law. You can do that with written or electronic notice. Going back to that lease section about why it's so important to figure out where am I supposed to send my notices. And if you send this letter, this demand letter, and nothing changes, and you file a lawsuit, you can see compensatory damages for the actual money the injury that you've, financial injury. You've got the $50 statutory damages for each violation of the statute, and a court can award a penalty of $50 to $1,000 for each violation. Those penalties are payable to the tenant or the homeowner. You can also seek costs, including attorney fees and any other equitable relief the court finds appropriate. Yes?
What obligation does the landlord have to provide a reasonable method of payment?
The methods of payment must be laid out in the lease agreement itself. So that kind of goes to when you're reviewing if you're reviewing the terms of the payment or the terms of the lease agreement, you're seeing, well, this payment method just isn't going to work for me. Then prior to signing it, I would recommend, trying to work out some kind of arrangements, or if a change in circumstances during the tenancy gives rise to a situation where the payment method it's not feasible or it's really burdensome, I would recommend reaching out and writing to your landlord and saying, hey, can we amend my contract? I'm having a real hard time with the payment methods as they're set forth, given some changes in my circumstances. And if you've already done that and you're still asking that question, I would recommend contacting Colorado Legal Services. Now you're getting too individual on me. All right. I appreciate the question, but that's why I can kind of paint in broad strokes here. But if you want me to get down to the details, you're going to hear me say a lot. Apply for services. Call the Justice Center. All right.
May I try another question?
Yeah, sure.
Okay, so on the payment of rent by one of the agencies, let's say, for example, Sarah, ERAP, one of those.
Uh-huh.
So if the landlord gets rent for the last 5 months, let's say, for instance, it came for 5 months worth of rent and it came in December, is the landlord able to charge late fees for the first 4 months that no payment occurred in the month in question? Because this happens.
It does, and it's happened in the last few years.
Yeah.
Rent subsidy provider.
Yeah.
I do not believe that the state is in the context of the rental assistance throughout the pandemic, that was rental assistance, but it was not a rental subsidy provider. The emergency housing vouchers that were referred to earlier by the Independent Center, that's a housing subsidy. All right.
And that would come on like a monthly basis, is that right?
You would have likely entered into a HAP contract.
Yeah. Okay. Thank you.
Yeah. Great question. So it is a defense against an eviction that you were charged even the late fees. Don't do this. If you're a landlord, don't do this. All right. Late fee, a late fee isn't rent. You can't deduct the late fee from the rent payment and say, well, thanks for paying your rent. You still owe me the $50, you're $50 short because I took it out. Don't. Just don't. All right. So we still haven't moved into the house yet that we're so excited to apply for at the beginning of this presentation. All right. So truck's out front, got the keys, door opens up, I'm home. Before you start bringing in all the boxes, before you start unloading, I updated the slide to bring it to 2023 because nobody carries around a camera anymore. We all have some kind of supercomputer in our pockets. So use that pixelated camera. Use all those pixels, go around, document everything. Light switches, faucets, dishwasher, any holes in the wall, any cracks you see. Open up the oven, take a picture of that. Open up under the oven, take a picture of that. Pull the oven, if you can wiggle the stove out a little bit, take a picture behind there. Document what the condition is. So why are these pictures important? Again, they document the condition of your residence at the beginning of your tenancy. Damaged or undamaged, take a picture of it, all right? Because at the conclusion of your tenancy, whether that's a month or 10 years, you want to be able to say, well, this is what the place looked like when you rented it to me, and it looks like that now. If your landlords, if this is not required, but I think taking this extra step is the best practice for both landlords and tenants, and that's doing a walkthrough of the unit before kind of turning the keys over to the new tenant. Because you and your landlord, you and your tenant, you're able to walk through together and say, that's a problem. You take a picture of it. You can say, well, look, I'm not going to fix that. I am going to fix that. Don't say I'm not going to fix that if it's something about the warranty of habitability, but if there's a paint defect on the wall, that's not the warranty of habitability. You can say, well, I'm not going to fix that next one. Okay. But then you enter into the contract. You enter into this business relationship on the same page as far as, well, this is what I am agreeing to pay you money to rent. And landlord says, this is what I am agreeing to sell you for the next 1 month, 6 months, 12 months, however long it may be. And then if you take the pictures, I would also recommend sending a copy to your landlord as well. That way they have a copy of that for their records as well. Landlords, if you don't want to keep it, that's up to you. But for tenants, I think that would be the best practice because you've shown that you documented them at the beginning of your tenancy and you provided that copy to your landlord as well. And it just kind of keeps transparency in the relationship. Be critical during this, but not unreasonable. You're not being a bother by pointing out any kind of existing damage. Remember, you're paying to live here, all right? And you're paying for the residents. And also, landlords don't take it personally because if they're pointing out something that may be small today, that small problem today may be a major catastrophe tomorrow. it's a business relationship and it's beneficial for both parties to have an understanding. Yes, sir.
What happens if the landlord refuses to fix the back window, the sink?
Back window, warranty of habitability and code enforcement. Sink, warranty of habitability and code enforcement. Garbage disposal. And we'll get to the warranty of habitability here in just a second. I throw my shoulders up and shrug at the garbage disposal because that is not specifically listed as an uninhabitable condition in Colorado statutes. Here we are. Thank you for the segue, sir. All right. This is the promise that your residence is fit for human beings to live in. There are a list of things that by law must be present or must not be present. In the packet, there's a list of that, but and we'll go through that as well. But let's start with electronic notice. A work order is not electronic notice. It is a work order. It is a repair request. Unless there is something more specific to put your landlord on notice that, because you can have a leaky sink, but you can also have a sink that is in such bad repair that it renders your home uninhabitable. And there's a scale here, a problem. But if it's of a level where you're saying, hey, this is my place is uninhabitable, let your landlord know my place is uninhabitable. If it's in the work order, if all you have is a portal to submit work orders, be more specific than I have a leaky faucet or a water leak. Include some kind of language saying this makes my residence uninhabitable. Because hopefully as a landlord, when you receive that message, you'll say, oh, this is priority, because the law requires that to be priority as well, which we'll get to. So what makes up an electronic notice? This is from the statute. So notice by electronic mail or electronic portal or management communications system that is available to both a landlord and a tenant. If you send an electronic notice, you must send it to only the email address, phone number, or electronic portal that is specified by the landlord in the agreement. So this is why, it's really important when you're reading your lease, this is clear, all right? And confirm the address with your landlord as well to make sure there aren't any typos, because you want things to get fixed and landlord wants to provide you with a good residence. Because if your rental agreement indicates to send it to an email address and then you send a text message, the law says that is not reasonably complete notice. You may still get a response, but if it's not following the steps laid out in your lease, it's not going to invoke the protections of the warranty of habitability in the sense of that if your landlord does not take responsive action to the text message when you were supposed to send an email, they're not going to be in breach because they never received the notice for the purposes of the warranty of habitability. So what if your lease is silent? Then you shall communicate with the landlord in a manner that the landlord has previously used to communicate with the tenant. So if your lease is silent, or this is a verbal agreement, because in a verbal agreement, you're not going to have anything written down about where to send anything. It's you can communicate in the way that's previously been used to communicate with you. If all you've ever done is have verbal conversations, and then you got a text message saying, Happy Thanksgiving. Now you can text because landlords communicated with you via text message. Same with email, all right? If you don't have any of that availability, you don't have an email, you don't have anything in your lease, you don't have a text message, there may be a breach of the warranty of habitability by not providing that information to you and not providing that avenue to you to provide that notice. So again, if the lease is silent, then practice controls. If your landlord texts, then you can text. If your landlord emails, then you can email. You must retain sufficient proof of delivery of the electronic notice. If you send a text message and then promptly throw the phone out, guess what? You're not going to be able to prove that. Yes?
So when it's simply an electronic portal being the only communication, right? When they have control of what stays in the portal and what doesn't.
What do you do?
Take a picture.
You can screenshot.
Okay,
Yeah, screenshot on your computer, all right? Or if you're on your phone,
right,
screenshot. But your computer does have a,
right,
if I knew the shortcut, I would just rattle it off. I don't.
right.
But you can screenshot whatever browser you have open. And if you're doing it on your phone, screenshot before you hit submit, screenshot after you hit submit.
But if that wasn't done, which will always be done moving forward, there has to be some sort of record of things that have been deleted or submitted, correct?
I would assume as much, and that's where you would have to start using subpoenas.
Yeah.
So we're probably getting a little too far in the weeds for this evening's purposes, but
Sure.
if something happened digitally,
Yeah.
chances are you could recreate what that digital record was. Is that going to be easy? My guess is no. But is it possible? I would imagine it would be. All right, so what are the conditions subject to the warranty of habitability? Before we get into this, let me go through questions in the chat real quick because they've probably been building up here. So,
And Quentin, you'll see a few where I just typed what's been asked in the room because I wasn't sure if the participants could hear that.
thank you.
The first one is from Dan, is the email a valid medium to use for written application denial? That's where they start.
I think it would be. What I think the best practice would be to attach a file to it, such as a PDF. I think signing documents with a real signature or something other than just a typed name, I think that's the best practice because then you as a signator can say, no, I didn't sign this document. This didn't come from me. You can see my business practice, which is to physically sign everything, docu-sign everything, and this does not meet with my business practices. So I do think, and the law just says, Dan, the law says that landlords have to make a good faith effort. And if all you have is an email address, I think that would satisfy as a good faith effort. I have a question. Okay. Explain the tenancy law about the number of days needed for a notice. The one about 3 to 90 days is tenancy referring to how much you have paid at once. So if you pay 1 year at a time, 91 days notice, it isn't how long you stay, it's how much you pay. I think that's kind of a broader question regarding the amount of notice required to terminate a tenancy for no cause. It's going to depend on the term of tenancy. And yes, if generally speaking, I'm comfortable with saying if you don't have a written agreement and you pay on a monthly basis, you're going to be considered a month-to-month tenant. If you pay on a quarterly basis, it's going to be a quarterly tenant, and kind of so on and so forth. I can say what the law is, but anything more than that, I think it's getting a little bit too specific. How does living on a military base impact protections for renters in Colorado Springs? That's a good question. I don't think it does because.
I've lived on military bases, I'm pretty sure it doesn't. I lived in Wyoming and here, and we would have to go through our own.
I have never seen a case from base. If you have more questions, I'm very sorry that I didn't answer that fully. I would recommend, honestly, if you're living on base, I would recommend contacting Jack. Because those attorneys are going to have a much better understanding of what protections may be available to you than I do. To Ms. O'Hare, your question is too specific for this forum. So as I indicated, that would probably be that you're going to have to apply for services if you'd like that question answered. This is just not the proper forum for that this evening. There's a question about denying an application for an emotional support animal. This is too fact specific for me to answer. the landlord would have to put in writing why they are denying your application. So if they deny your application for having an emotional support animal, likely want to provide them with a reasonable accommodation request. If that reasonable accommodation request is denied, and you want to contact an attorney to discuss potential fair housing remedies, and we will get to that later on in this presentation.
May I add to that question? If I may, what's the rule for what is an emotional support animal?
We'll get to that.
Oh, you will, great, okay. I mean, a burrow in the house.
You guys
is
are
a little
asking
bit-
me you're asking me all the questions under the sun, and we haven't even gone through half of it. We ain't even got through the conditions yet. All right, is the max late fee $50 or 5%, whichever is higher? It's whichever is higher. So for $500 rent, 5% of that would be, thank you, $25. So $50 would be the maximum. For $2,000 rent, the maximum would be $100 because 100 would be 5%. Yes, Dan?
And you missed one
I did miss
earlier.
one. Okay.
Can a roommate that moves
Oh,
out,
that's
for
right.
example, release or waive their security deposit?
Maybe? There's nothing kind of preventing the roommate from assigning that deposit to the other roommate. I've never actually run into this situation. It would likely be, it might be okay between roommates, but you still, unless, there would have to be something in writing here. I would need more information. Because you still can't waive the return from the landlord. And there's also another roommate still living there. Which is kind of an interesting. What the tenant cannot waive the right to the return of the security deposit means that as a tenant, the question was, does that mean that if we didn't cause damage and didn't violate the terms of the lease, that we don't have the right to get our deposit back? It's in fact the opposite of that. It means that you cannot waive your right to get a deposit back. That doesn't mean you will get your deposit back. It means you cannot waive your right to get a deposit back. And we will touch on security deposits a little bit later in this presentation. So I want to get to questions, and we haven't gotten through much of it yet. So conditions subject to the warranty of habitability. All right. Yep. Google image search can get you some cool things. All right, so waterproofing and weather protections of your roof, walls, doors, and windows. So that broken window, it's a problem. Plumbing and gas in good working order. Running water, reasonable amounts of hot water, proper fixtures and connections to sewage disposal systems. Functioning heating facilities in good working order and in compliance with the law.
It's considered good working order for a furnace.
It works. Contact code enforcement would be my better answer rather than me just sitting here looking like fish. So I don't know because I have no technical expertise in that area. It's going to depend on the device, honestly. It may not be working super efficiently, but I think that if it's still kind of, hold on. I think if it's still functioning as its intended purpose without any kind of detrimental effects, that may be what good working order is. But I don't know. I don't know. Again, that's why I'm saying, so in that situation, I would recommend contacting code enforcement when you're dealing with that. So code enforcement is going to be to enforce the code standards, and I'll get to this after these slides. The warranty of habitability, that gets enforced in court. All right. Electrical wiring and equipment in good working order and compliance with the law. Also, I didn't write the law, so they didn't define good working order. But again, that's going to be subjective, kind of, in my opinion, based upon what we're talking about as far as what the problematic issue is and kind of what will be determined, what somebody looks at, what an expert looks at when looking at a water heater, looking at a furnace, looking at a breaker box, as far as kind of what good work constitutes good working order for each individual item. And I'm just not going to pretend that I have any expertise in that area. Common areas under control of the landlord must be kept reasonably clean. this one isn't one of the stronger protections under the warranty of habitability because this only comes up if the common area is in such a state of disrepair that you're not able to use your residence. So meet our friends. So there's got to be an appropriate extermination in response to any kind of infestation. There are specific procedures lined out for bed bugs. As a tenant, you have the warranty of habitability imposes duties on the landlord, but as a tenant, you have to do things too. You can't sit around and wait until the problem gets really bad. You have to contact your landlord immediately. So you shall promptly notify the landlord via written or electronic notice when you know or you reasonably suspect that you have bed bugs. And landlords, when you get that notice, within 96 hours of getting that notice, within 4 days, you have to provide the tenant with 48 hours of notice of you, an inspector, or a pest control agent's intent to enter the dwelling, and you must obtain an inspection by a qualified inspector. Landlords, you're able to enter that unit and any contiguous unit for the purpose of inspection. Because, I mean, shoot, if it were me, I'd want to know if those little buggers have spread. If the inspection confirms bed bugs, then you shall inspect all contiguous units. So before the inspection, you have the right to inspect the contiguous units. If you choose not to, and you only inspect the unit where you received the notice of, and that inspection came back positive, now you have to inspect all the other units that are contiguous to that unit. So landlords, you are responsible for all costs associated with an inspection for and treatment of bed bugs. You are not able to determine where the bed bugs came from. You're not. They didn't leave it, they didn't RSVP to the party. You don't know where they came from, you don't know how they got there, and they can be dormant for a very long time. It's uncertain if the current tenant's even the one that brought them in, or if they came from a guest that was staying at a neighbor's place and brought one in on a suitcase or in the cuff of their pants and flicked off and decided that I'm home now. All right, so after the inspection, I'm sorry, you had a question? Okay, sorry. I saw your hand there a second ago. Landlord must give the tenant written notice within 2 business days whether the dwelling unit contains bed bugs. So even if you get the inspection done and your inspector comes back and says, good news, no bed bugs. Oh, thank goodness, I'll tell my tenant that. You also have to tell the tenant that if their concerns remain, they can contact the local health department. If the inspector confirms the presence of bed bugs, then the inspector must provide a report to the landlord within 24 hours. Landlords, if you're thinking, well, what happens if the inspector doesn't do that? You may have a cause of action against them. It also may provide a defense to you if there's any allegation of the breach of the warranty of habitability. But I would get on that inspector and make sure you get that report ASAP. So not more than 5 business days after the inspection, the landlord shall commence remedial measures to effectively treat the bed bug presence. The landlord shall commence remedial measures. Landlord, do not hand your tenant a can of Raid and say, have fun. That's not an appropriate response. And if you've ever dealt with bed bugs, you know that's not going to get them out either. And the infestation is just going to get worse, and it's going to become more expensive the worse it gets. Tenants, if you make this complaint or if an inspection is coming, you have to follow the rules of the inspection. There are going to be requirements for you. You're likely going to have to bag up clothing. You're going to have to take furniture away from the walls. If it's upholstered, you're likely going to have to flip it up. You may have to rip out the bottom parts of it too. You have to do that. Because if you don't do that, you're not getting a full inspection. And if you have to go out and you have to buy tubs, that cost falls on you as a tenant, right? And this is why you have to do it. If you knowingly and unreasonably fail to comply with the inspection and the treatment requirements, as a tenant, you can be liable for the cost of any treatments and contiguous dwelling units if the need for treatment of those units arises from your non-compliance. So you've got to let your landlord come in to treat for bed bugs. Landlords are not allowed to rent a unit that you know or reasonably suspect to contain bed bugs. And if an applicant asks you, you are required to disclose to that applicant whether, to your knowledge, the unit contained bed bugs within the last 8 months and or disclose the last date that the unit was inspected for and found to be free of bed bugs. Landlords, if you don't comply with this section, you're responsible for the tenant's actual damages. And a landlord also, landlords, if you run into a tenant where they're not providing access, they're not allowing you to inspect, they're not allowing you to treat, you can file for injunctive relief with the court to try to kind of get the court to say to the tenant, you need to stop preventing this and allow the treatment or allow the inspection to happen. If a court finds that a tenant has unreasonably failed to comply, the court may issue an order including granting the landlord access to the dwelling, granting the landlord the right to inspect and treat the dwelling, requiring the tenant to comply with a specific inspection and treatment measures, or assessing the costs and damages related to the non-compliance. All right, moving on from bed bugs. You also have to have an adequate amount of outside receptacles for garbage. If you have a 90-unit building, I would imagine that one trash can, like one of these, is not going to be sufficient. I've not seen this particular issue come up, but it is in the statute.
Is that for single family houses too, or no?
Unless the single family house is accepted from the warranty of habitability. I think trash service is a little bit different in that context. So that's kind of the road we're heading down, more of kind of a utility. But it's something, like I said, also, I've not run into that specifically. So you're asking me what is a violation that look like? Curious myself. But also, you must have working floors, stairways, and railings, locks on exterior doors, and security devices on windows that open. Compliance with all applicable building, housing, and health codes, which materially interferes with your life, health, or safety. There's also a mold section here. Mold is defined as microscopic organisms, and y'all, I'm going to go pretty quickly here through mold. The slides are available to you. You've all registered. You're all here. So there's the definition of mold. We're going to talk about timelines in a second. Appliances, refrigerator, range stove, or oven included with the residence for use of the tenant pursuant to the agreement or any other agreement between the landlord and the tenant that applies only to the appliances specifically listed in your written agreement or otherwise actually provided by your landlord at the beginning of tenancy. If you make a demand based upon your appliances, your landlord replaces the appliance. As long as it does the same thing, it's not considered retaliation. The example I use in this, if I have to kind of stretch to find one, if you have one of those fancy smart fridges now that have a TV built into them and it breaks, and you get a refrigerator that doesn't have a television in it, it's still a refrigerator. It's not retaliatory. Also, there's conditions that one of the kind of, this affects timelines. If we're talking about a condition that materially interferes with life, health, or safety, it's subjective based upon the tenant's individual characteristics. Or do you have a power cord?
Oh, it's plugged in right now, is that not? Okay, if you have to switch to this machine, you can. Is it saying that it's going out?
Was. Let's see. All right, well, I'll keep going until the computer shuts off. All right.
Here, I'm back to my computer.
All right, thumb drive. All right, here's the thumb drive. Yeah. All right, so it significantly alters the landlord response. We'll get to that in just a little bit. When does the landlord breach the warranty of habitability? It is not just that your residence is uninhabitable. It is that your residence is uninhabitable by one of those conditions on the list, or it's in a condition that materially interferes with the tenant's life, health, or safety, and the landlord has received your reasonably complete written or electronic notice of the condition and failed to commence remedial action by employing reasonable efforts within the required times. When do we have to start doing work? There are 3 different timelines: material interference with life, health, or safety, uninhabitable by statute, or mold. Life, health, or safety, landlords, you have 24 hours to commence remedial action. Statutory condition, you have 96 hours. But this only applies if the tenant has included permission for the landlord or the landlord's agent to enter the premises. So going back to those notices, if it's just a portal notice, include this makes my home uninhabitable, and I give you or your agent permission to enter the premises for the purposes of repairing the uninhabitable condition. Oh, no, that's. I don't know what just happened, so bear with me. Okay. Mold, 96 hours after receiving notice. There's a lot of steps here where I want to kind of move through this. I'm sorry, y'all. The slides are in the packet, or they're going to be sent out. And when do you have to, landlords, you have to respond to a notice? Yes. Tenants, your landlord has to respond to you when that happens. They have to provide a response to a reasonably complete notice within 24 hours of receiving the notice. The response must contain the following information. It must contain your landlord's intention to remedy the condition, an estimate of when those repairs are going to start, and an estimate of when those repairs are going to finish. I see the smile back there. I can imagine that has not occurred in response to your prior portal issues. What about an alternate residence? Right? In some situations, yes. Not all situations, but some. So if the residence is in a condition that materially interferes with your life, health, or safety, and you make a request, oh, that's a great video freeze. Great. I'm glad that's memorialized. So if you make a request, then it will be. Are we still broadcasting? Okay. Then it will be. And if you make the request for the alternate residence, then your landlord will provide you with either a similar dwelling or a hotel room of their choosing at no cost to you as the tenant.
But it has to be requested.
It does have to be requested. As a tenant, you do have to make that affirmative request for it.
So is that law? Is that a law?
Yeah, it's in the warranty. It's in the warranty of habitability. This was an update to the warranty of habitability within the last few years.
So I ran into a situation like that.
If you're about to get into that situation, sir, keep in mind that I'm unable to provide legal advice in this setting. And if it's a conversation you'd like to have with me or somebody else at CLS further, you're going to have to apply. All right. I'm not trying to.
Why don't you use mine because I'm already connected.
All right.
I just got your.
Okay.
So,
40 minutes, all we wanted is 40 minutes.
The battery couldn't last 40 minutes.
All right. I can appreciate the frustration of, I just have this one, I got a question. But if it's a serious question, then you want a serious answer, right?
Yeah.
And for me, if I'm just sitting up here spitballing, I'm not giving you a serious answer as an attorney when I'm talking in a room full of people to you. So I'm not trying to blow off the question at all. What I am saying is just give us a call. Give us a call to apply for services, and hopefully somebody be able to actually sit down with you, have that conversation with you, and lay out what your options are. I'm just trying to squeeze about 8 different areas of the law into an hour and then open it up for questions. So it's just kind of difficult for me to cover everything.
So your presentation is up, but the video has changed, but
Okay.
it still should be
All right, can everybody,
See the
Can't see
video
the
on the Zoom feed. That's the only problem.
Right, we can't see this video.
I mean, we can't see the slides on
We
the.
can't see the slides. Oh, I have the slides are showing.
So. Oh, wait, now it's showing. Never mind. We're good. It's okay, Barb.
Okay.
everybody can see the slides online?
Yes.
All right. Now, where were we?
Sorry about that.
Alternate residents.
Thank you.
Yay.
All right, so we're past bed bugs. So we're past. All right, alternate residents. Thank you for your patience, folks online. Thank you for your patience and your understanding. Sorry about that. All right. Again, if it's in a condition that materially interferes with your life, health, or safety, and you make a request, then the landlord shall provide a comparable dwelling unit as selected by the landlord at no expense or cost to the tenant, or a hotel room as selected by the landlord at no expense or cost to the tenant. Landlords are responsible for that cost of either the hotel room
Sorry.
or the
There we
Too
go.
tall.
That's good.
all right. I mean, we're about to find out. So landlords, you're not responsible for relocation fees. You're responsible for the cost of either that comparable dwelling unit or the hotel room. You're not responsible for other costs that arise after that relocation period. Tenants, you're still responsible for your rent during this time period. So even if your place is uninhabitable and you're put up in a hotel room, you're still responsible for your rent. And again, this only applies to conditions that materially interfere with life, health, or safety. So what can you do if your landlord's in breach of that warranty of habitability? After providing proper notice and not receiving a response or remedial action, you can terminate the lease. You can obtain injunctive relief in either the county court or the district court. You can defend against an eviction for non-payment of rent. There are other monetary options as well. Withholding rent. So if you're considering this, before you consider this, speak to an attorney, all right? Because if you wrongfully withhold your rent, you may risk an eviction for no reason. When if you pay your rent in full and you file a small claims action, your damages would be the diminution in rental value. That's part of your damages, meaning how much did I overpay for my apartment that didn't have heat in January? All right, so monetary options, withholding rent. Now this is good. This first one's with a caveat here, and we'll get to that in a second, which is needing to pay the amount withheld to the court to defend yourself against an eviction for non-payment. That law has changed to provide a hearing for folks who are indigent, because it used to be that if you were indigent, the warranty of habitability was not a defense for you. So if there's a problem with the notice that you provided to your landlord, then there is not going to be a defense. So again, I'd recommend seeking legal advice before taking this step, because also keep in mind, you can bring a claim for breach of the warranty of habitability outside of an eviction. You don't have to wait to get an eviction notice. You don't have to wait to get a summons and complaint. You don't have to put the roof over your head in jeopardy. You too can go to court first. All right. Deducting cost of repairs. It's an incredibly specific process. It does not apply to everyone. It does not apply to every rental residence. You cannot deduct for certain issues. There are competing estimates. If you have a cousin that's a contractor, you can't use that cousin because you can't be related to that person. And if you wrongfully deduct, then your landlord will get a money judgment in that amount withheld, and you will also likely be evicted for non-payment. If it is a bad faith deduction, you'll automatically be evicted, and there'll be a money judgment entered in your landlord's favor for 2 times the amount withheld. I'd speak to a lawyer before you consider doing this. I think there are very many pitfalls in that statute, and at the end of the day, you're not guaranteed the relief that you are seeking. So are there exceptions to the warranty of habitability? Yes. But this must be in a written agreement that is separate from the lease, that is signed by both parties and is supported by adequate consideration. What is consideration? Money or rent deduction, right? So you're a journeyman electrician, you're a carpenter, you're a skilled tradesman. You enter into a lease agreement and your landlord says, hey, I see you have some electrical work in your background. Well, if I knock $200 a month off the rent, would you agree to maintain all the electrical in the property? Sure, let's put it in writing. Then now you have a separate agreement where you've gotten your consideration, which is your rent deduction, and you've identified what it is that you are going to be responsible for as a tenant. But you also have to have the skills to perform the work. I'm never signing any of those agreements because I am not skilled to do any of that work. So if you're unsure about whether this applies to you, please seek legal advice. So a breach of the warranty of habitability is also a defense in a collections action. I indicated earlier it's a defense in an eviction for non-payment. It is also a defense in a collection action. So if, as a tenant, you raise the warranty of habitability as a defense, you will have to post a bond unless you are found to be indigent. Then you will not be required to pay a bond to raise the warranty of habitability as an affirmative defense. Here's the calculation for determining indigency. I would just refer to the slides. Please request them. We're just kind of running out of time here, and I want to get to y'all's questions. So the court shall determine, so if you're in trial on this issue, the court's going to make a determination on what the fair market value of the property was in its uninhabitable state to the date of the trial. The court shall, if the court finds that there was a breach of the warranty of habitability, they're going to deny possession to the landlord and deem the tenant the prevailing party. The tenant has to then pay the rent that has accrued to the date of trial, taking the reduction of value into consideration. That payment must be made either to the court or the landlord within 14 days of the court's judgment. Now, if you're a tenant and you get this favorable ruling and you don't make that payment within 14 days, you've now lost. And that's now been reversed because the court's going to award possession to your landlord and you're going to be evicted if you don't pay that reduced amount within those 14 days. The court may order landlords to make repairs and correct uninhabitable conditions, and the court shall order that the monthly rent be limited to that lowered value until the repairs are completed. If the court orders repairs to be made, the court keeps the case open to ensure compliance with the court orders. Some other resources, if you're experiencing conditions issues in your residence, are going to be the Colorado Springs Planning and Community Development Neighborhood Services Office, the Department of Health, or the El Paso County Planning and Community Development Office. Code enforcement only has the authority to enforce the minimum housing standards of the city code. They do not have the ability to enforce the warranty of habitability. Some issues are not included in city code that are in the warranty of habitability. Some are included in the city code that are not included in the warranty of habitability. Example, window screens. You can call both, but the warranty of habitability is for court, code enforcement is for the city code. So you can always contact code enforcement if you're dealing with uninhabitable conditions. Keep in mind though, that some of those conditions may not actually be in the city code. Security deposit, your landlord can only keep your deposit for damage beyond normal wear and tear, for non-payment of rent, for the abandonment of the residence, and for non-payment of utilities, repairs, cleaning work contracted for by you, the tenant. What is normal wear and tear? This is the usual deterioration which occurs when living in a residence. What is not normal wear and tear? Careless or intentional destruction of the property. If you punch a hole in the wall, that's not normal. What should you do when you move out? And folks, I know I'm going really fast, but we are just kind of running out of time right now. Clean the residence, top to bottom. Another walkthrough, take more pictures. Go back and look at those pictures you took at the beginning. Go through and take the same photographs at the end. Return the keys and provide a forwarding address to your landlord. If you don't provide a forwarding address to your landlord has no obligation to find out your new address to send you your security deposit. All they have to do is send it to the last known address they have. Well, what is that? If you just moved out and you didn't provide a forwarding address, the last known address is the address everybody knows you don't live at. So as a tenant, make sure that you let your landlord know, hey, here's where you can send email in the future.
And just
Yes.
a reminder, we are scheduled till 8.
Okay.
I wasn't sure if you were.
Is that a hard deadline at 8? I also wanted to open it up for
I
questions.
think that is a hard deadline.
Okay.
I just wanted to
I've
take all
I've messed around with hard deadlines and we have gotten to the hell of Q&A before. So how long does my landlord have to return my deposit? It's going to be 30 days. In your lease, that time period can be extended up to 60 days. What happens if your landlord does not return your deposit? Send a demand letter. I used to say send it, if you can send it via certified mail, great. But if you send it to a PO box, guess what? No one's going to be there to sign for it. It's going to circle around and you're going to get it returned in a couple months. Keep a copy of the letter, but I would recommend sending some kind of tracking just so you can prove delivery. Here are sample letters you can use. They're in the packet, they're in the slides, moving on. Your landlord may only refund part of your deposit, but if that happens, you are still entitled to an accounting statement stating the reasons you are not receiving the full refund of your deposit. So you send out one of those demand letters that just flash up on the screen, and you don't get a response or you don't get a satisfactory response. You can file a small claims action or an action. You can file a small claims action if the amount being sought is $7,500 or less. With security deposits, you can seek treble damages, meaning 3 times the amount that is wrongfully withheld. Early lease termination. When is it allowed? Sometimes the language of the lease will have that built into it. If there are a breach of the warranty of habitability or multiple breaches of the warranty of habitability within a 6-month period, there are also additional protections for the victims of domestic violence, domestic abuse, stalking, and/or unlawful sexual behavior. If you find yourself in that situation, and you are looking to terminate your lease for your safety and your protection, you need to provide your landlord with proof of your status as a victim, and you need to pay 1 month rent within 90 days of moving out in order to receive your security deposit back. Military orders, act of God, so long as it's not caused by your negligence. For example, forest fire, act of God. I was sleeping on the couch, smoking a cigarette, and not an act of God. So again, multiple warranty of habitability breaches. If the same condition of the residence renders the home uninhabitable twice within a 6-month period, and the condition is not appliance related, you can have numerous broken refrigerators. You have to provide your landlord with a 14-day notice stating I'm terminating my tenancy. This is the second time in the last 6-month period that my home is uninhabitable due to this condition. On the second one, you don't have to give your landlords, you don't have an opportunity to remedy the problem on the second breach or the second uninhabitable condition. Maybe the tenant wants to remain, but the tenant does not have to provide you with that opportunity to fix it. Mobile Home Park Act. Additional right to if you're in a park, you are required to, if you own your home in a mobile home park, you have a right to a written lease or rental agreement. The termination must be for cause, as opposed to a no-cause termination, which is what we often refer to as just a notice to quit. Demand, you have a 90-day cure period for demand. You have 90 days to move or sell the home for a notice to quit. The security deposit cannot be greater than 1 month rent. And folks, given the time press, I am going to, management shall adequately disclose the terms and conditions of the tenancy in writing. And it has what is required in those disclosures. Here are the reasons that your tenancy can be terminated. These are the 4 cause reasons. In parks, oftentimes, in every park, there are going to be some list of written rules and regulations. Those rules and regulations can be changed. If it is changed with your permission, those rules go into effect immediately. If those rules are changed and you do not agree with those rules, they go into effect, but not for 60 days. So the homeowner right to privacy, this is limited to homeowners in the mobile home park. Park management has no right to enter a homeowner's home without first obtaining the written consent of the homeowner to carry out statutory duties in the case of an emergency or when the home has been abandoned. Written consent may be revoked at any time. The notice of entry must include the date and approximate time of planned entry and be delivered in manner reasonably likely to be seen or heard by the resident and tenant landlord. All right, so this next section is about the Mobile Home Dispute Resolution Act. This is a alternate dispute resolution method provided by the Colorado Division of Housing. It's available to park management and park residents. And unfortunately, I'm going to skip through this evening because we just don't have the time. And here are the updates. There are also updates from 2022 to the Mobile Home Park Act. Again, I am trying to get to eviction process, which we still have not gotten to yet. So I apologize if you had questions related to 2022 updates to the Mobile Home Park Act. Those updates are laid out in the slides, which will be made available to you after tonight's presentation. This is the court procedure for evictions in Colorado. Landlords are required to use the court process. You cannot resort to self-help. There are a number of reasons that a landlord has a right to seek a judgment for possession. The first step is going to be a notice or a demand. These are the JDF forms. These are not required to be the forms. These are available online. Again, there's no specific language or state form required for the notice or demand. It doesn't have to be notarized. It doesn't have to be signed by a judge. In fact, it would be very weird if it was signed by a judge because it's a notice or a demand and you haven't gotten to it yet. So a notice has to describe the property, has to state the date and time of the termination of the tenancy, has to be signed by the landlord, and it must be served by statutory deadlines. Going back to a question from the chat earlier this evening, the 3 to 90 days is going to be determinative. Is whether you're entitled to 3 days or 91 days, is going to be determined by the length of your tenancy period. If you're on a month-to-month lease, you are on a month-long tenancy. Even if you have lived in the same residence for 25 years, if you have been on a month-to-month lease for 25 years, you only have a right to 21 days of written notice for your tenancy to be terminated. So, what should you do if you get a demand or a notice? Well, a demand for compliance is going to say that you breached your lease and that you have 10 days or 5 days to fix it. And if we're talking about non-payment, contact to see if there are rental assistance still available. You can also contact your landlord to try to work out a payment plan to get caught up. For other violations or other alleged violations, provide your landlord with some kind of documentation that the violation did not occur, that this is a mistake, this is a misunderstanding, or hey, it wasn't me. I was in Iowa. I don't know what you're talking about. Or provide your landlord with documentation showing that the violation has been cured. Right? So I would recommend doing that within the 10-day period. It's good to practice that communication with your landlord. And also your landlord has some kind of response from you that shows, oh, we fixed it. Okay, well, I guess I don't have to go to court. Great. Glad this problem got solved. Notice to quit for substantial violation. Broadly speaking, this is endangering the person, endangering the property, guns and drug felonies, and public nuisance crimes. Public nuisance doesn't mean that you're annoyed. It's a long list of things that include things like illegal bong shops, brothels, betting parlors, just kind of vices. Notice to quit for repeat violation. This means that your landlord is claiming that you have violated the same lease provision twice within a 12-month period. You may want to provide your landlord with documentation showing you did not violate the lease provision a second time. Notice to quit. This is a no-cost. This is a form that doesn't state a reason. It's just stating that your tenancy is ending on this date. Make sure that this complies with your lease. You can contact your landlord to work out a lease extension, or if it appears that this does what your lease requires, your landlord does not want to work anything out with you. At that point, start preparing to move.
When you say comply with the lease, does that mean the dates that you've been paying?
That means that your lease says I'm entitled, if you want to terminate this lease contract, I'm entitled to, either party can do that, but they have to provide 30-day notice. So you're looking at a 10-day notice month. 10's not 30.
Is it 30 days from when you're normally paying your rent? Not 30 days or any 30 days within the month?
No. Let me back up. A notice to quit, it is statutory deadline, so it's 21 days prior to the end of the applicable tenancy period. Not just 21 days. 21 days prior to the end of the applicable tenancy period. If you're on a month-to-month lease, that's 21 days before the end of the month. If you're on a week-to-week tenancy, that's 3 days before the end of the tenancy period. If you're on a year or longer lease, that's 91 days before the end of that year or longer period. And if you're counting out the day that you serve that notice doesn't count. So not just 30 days, 30 days prior to the end of the month. Because think about it, if you get into the next month and you pay your rent, you've purchased a month of tenancy. So you've gotten the notice or demand and the time limits run out. The next step is going to be to file a summons and complaint. This is the court paperwork. This is when you're going to court. Summons, there's language that must be required. There's language required to be included in the summons, a blank answer form, a form requesting documents, a list of available resources, such as contact information for Colorado Legal Services. There's your statute for what must be included in a summons form. That's 1341-111. Service, personal service, or service by posting. If it's served by posting, I'm going to move forward. Answer, this is your legal defense in response to the complaint, right? Emphasis there is on legal defense. I have seen a number of cases that are absolutely heartbreaking, and the law doesn't care. There's not any kind of, the law does not provide judges with discretion when it comes to eviction matters. So an answer in a trial setting, like I said, the answer sets forth your legal defenses. That must be filed on or before the close of business on your return date. Answer due by 5 p.m. on the date of the return. Any defense regarding an improper notice must be raised in the answer or by filing a motion pre-hearing. You cannot raise an invalid, improper notice defense for the first time at trial. After the answer is filed, the court shall set a trial 7 to 10 days after an answer is filed. For forcible entry and detainer cases, you do not have a right to a jury trial. Between the filing of the answer and the trial itself, the court's going to order that the landlord and or the tenant provide any documentation relevant to the current action. If you have paperwork you're going to rely on in the hearing, you got to turn it over to the other side. Curing non-payment of rent. So landlords, if we're talking about a non-payment case, you have a duty to accept the payment. That's how the law is written. You shall accept payment of the tenant's full payment of all amounts due according to the notice, right? So that means that even though once the 10-day period expires on a demand for compliance for payment, a demand for compliance, whatever that may be, as a landlord, you have a right to file an eviction case. You also have the duty, the continuing duty, to accept payment, right? Tenants may pay that amount to you as the landlord directly, or if you say I'm not taking your money, they'll pay it to the court. And then you're gonna have to wait because you're gonna have to file a motion to get your money out of the court. Once the court confirms that the full amount has been timely paid, the court shall vacate any judgments that have been issued and dismiss the action with prejudice. There is also a defense in eviction, another defense based on the warranty of habitability beyond non-payment, and that's kind of in a retaliatory sense, is that if your landlord retaliates against you as a tenant for making a good faith complaint to the landlord or a governmental agency regarding warranty of habitability, or organizing or becoming a member of a tenants association or similar organization, it is a defense that this was done in retaliation for the warranty of habitability. Please keep in mind that timing alone is not sufficient proof of retaliation. It has to be more than just these events happen back to back. There's just got to be more than timing. As a tenant, you can say that the breach of the habitability is actually a defense to a non-monetary eviction, such as a rule violation or a notice to quit. Again, the timing is not proof of that, though. There has to be something more than just the timing. Make sure to appear at your return date. Why is appear put in quotes? That's a weird thing to put in quotes, because in El Paso County, we have non-appearance return dates. So you're going to get a summons that says show up to court on, let's say, March 15th at 8:30. and you're gonna walk around the courthouse tomorrow morning going, where am I supposed to be? Because it's a non-appearance. So what you have to do is by, at least here in El Paso County, if you're in another county, please contact your local court for the local procedures. You have to file an answer or file a settlement. That's what you have to do by 5 o'clock on your return date. That's how you appear. Writ of restitution. This is the document that allows the sheriff, law enforcement to come into the property, remove you from the property, and return possession of the property back to your landlord. The court may issue a writ of restitution 48 hours after an entry of a judgment for possession. Judgment for possession is the legal phrase for eviction. Law enforcement cannot execute the writ until 10 days after the judgment. Unlawful removal or exclusion, meaning illegal eviction, just broadly speaking, just very briefly, if your landlord does not resort to the court process or tries to do a constructive eviction, like turn off your utilities, change the locks on you, remove the doors, you can bring a lawsuit and seek a minimum of 3 times the monthly rent or $5,000, whichever is higher, plus the actual damages. And court can also order possession be restored to a tenant who was unlawfully removed or excluded from a dwelling. Fair housing. Fair housing prohibits discrimination based on race, color, disability, sex, sexual orientation, including transgender status, national origin, national ancestry, religion, creed, marital status, and or familial status. There's, and I apologize, I did not check the status of this legislation before this evening. There was new legislation in Colorado to add gender identity and gender expression as protected classes. There are exceptions to the Fair Housing Act, and those exceptions are for owner-occupied buildings with 4 units or less, single-family housing sold or rented without the use of a broker, housing operated by organizations and private clubs that limit occupancy to members. And additionally, in Colorado, there's also a prohibition on the discrimination based on the source of income. So can't discriminate against a person based on their source of income. Source of income means any lawful and verifiable source of money paid directly, indirectly, or on behalf of a person, including income derived from a lawful profession or occupation and income or rental payments derived from any government or private assistance, grant, or loan program. There's a link to the income discrimination. Emotional support versus, service animals versus emotional support animals. Service animals, Americans with Disabilities Act. Emotional support animals, Fair Housing Act. Service animal, only a dog or a miniature horse. That's it. That's it. It's not a pet. It's a medical device. Same thing as a nebulizer, an inhaler, an oxygen tank. That's what that miniature horse is doing in your lobby. It's trained for a specific task. I see that weird blank. You think, miniature horse? I've never seen one of those. They do exist. They are trained for specific purposes. And those are the only 2 that are recognized by the only 2 types of animals recognized by the Americans with Disabilities Act. An emotional support animal is not protected by the Americans with Disabilities Act, but it does receive fair housing protections because, in theory, the emotional support animal is intended to provide the individual with the opportunity to enjoy their life, their residence to the fullest extent, given everything that they are dealing with, and the emotional support animal is part of that kind of treatment plan. Since this is different from a service animal, an emotional support animal is not automatic like a service animal would be. If you are a tenant and you have an emotional support animal, and that's not being honored, what you're going to want to do is make a reasonable accommodation request. Well, what's a reasonable accommodation request? So it is discriminatory and it is discrimination to refuse to make reasonable accommodations necessary to afford a person with a disability the equal opportunity to use and enjoy the residence. There's no magic language to make this request. I would advise including the words reasonable accommodation and what the specific request is. So it has to be in writing. like everything else. And that's why I lead off this presentation by saying, put everything in writing, because if you don't put it in writing, it's only going to be worth the paper it's written on. It must actually state what the actual accommodation is that you are looking for, not just that you are requesting, not I am disabled, I need a reasonable accommodation. It's I am requesting a reserved parking spot so that I may, as a reasonable accommodation, so I may have the equal opportunity to use and enjoy my residence. I'm requesting an accommodation towards the pet policy to accommodate my emotional support animal so that I may have an equal opportunity to use and enjoy the residence. Specifically state what it is that you are asking.
Can that be denied then?
Yeah, it can be denied. And then you start getting into fair housing litigation. So it can be denied if it is an unreasonable request. Let's say it's, well, I need you to install an elevator. Like this building was built in 1940. You can't build an elevator. No, it's not. It may be something that we can't build an elevator, but we can give you a first floor unit.
So an emotional support animal, can that be denied?
Yes,
It can be.
it can be. It is the denial, but the question you're asking is the denial proper? I don't know. But if the question says, can this be denied? Yeah, it can be denied. Is that right? I don't know. That's the next question is it right? And that's going to be where we get to a case-by-case analysis of whether or not this was a reasonable request and whether or not it was discriminatory in its refusal. All right, there's a sample letter. It's going to be on the slides. Got about 10 minutes. So I appreciate your folks' patience throughout the technical difficulties this evening. All right, I'm going to. All right, I'm going to grab the questions online real quick first.
Quentin, the first new one is at 7:15 p.m. Next question.
Yep. 7. What is the security device required on all functioning? On all functioning windows to lock. Is material interference with life health subjective? Yes. I don't know if the second part of that question about a deadbolt versus a chain latch, I don't think that would be sufficient for a warranty of habitability issue.
And then the last one's at the very bottom.
So if the last question here is, so if I'm on a month-to-month lease, they can give me an eviction notice 9-ish days after the first of the month. If I have a year-long lease, can I still get an eviction notice for not paying rent on September 9th or July 8th?
I think they just had a question about that timeline.
If we're talking about a notice to quit, one of the things with a notice to quit is also to check your lease. If your lease has, and this is at the beginning why I let off with that, one of the reasons is, look at that rollover provision, what happens at the end of my lease term. Your lease, you may have a year-long lease, and it may be written in such that it just ends. And if your lease just ends, you don't have a right to a notice to quit because you've been given the notice when you signed the lease. Because that's why you had to read the lease to know, hey, this isn't being renewed. I've got 6 months, I've got 12 months, I've got 8 weeks, whatever the time period may be. But that's what I have. If it's a month-to-month lease, it has to be 21 days before the end of the applicable tenancy period. The easy example is the first of the month, but I've seen leases where rent is due on the 5th, rent is due on the 15th. So I don't want to say it's always going to be the end of the month. It's going to be the end of the applicable tenancy period, whatever that may be in your individual situation. If you have a year-long lease and you don't pay rent, you can be evicted for non-payment of rent. If I'm understanding the second part of this question, if I have a year-long lease, can I still get an eviction notice for not paying rent on July 9th? Yes. On July 8th? Yes. Okay, Cool. I answered the question. That's all right. Thank you for the good question. Sorry for my confusion on that. Folks, any other questions from everybody in the room this evening? All right.
So in the lease, should there be any detail about like emergency contact? Should they be including something, so especially if it's in a building situation, and if something happens like overnight? Like, should there be procedures or certain?
Would it be best practices? Yes. Is it required by the warranty of habitability? It is not a requirement of the warranty of habitability to include a 24-hour kind of contact. Yes, sir.
How often do you have these?
Quarterly. So next one should be June?
Yeah.
Cool.
Approximately.
Approximately June.
Yeah.
Yes.
Did I hear right when I called about legal help today that you guys have walk-ins at 8:30 to apply for legal?
At the
help?
office?
Yeah.
Yeah. You can come in to apply 8:30 to noon, 1 to 5, Monday through Friday. You don't need an appointment to come in and apply. We're also, sorry, Deb, I thought that was another question.
Oh, no, I'm just.
So in addition to applying in person at our office, you can apply for services online at www.coloradolegalservices.org. You can apply over the phone at extension 444. If you are facing a housing issue, we also have a housing clinic in the courthouse in room W163. That's going to be in the West Tower, kind of tucked back in the corner. We're there Tuesday and Thursday from 8:30 to noon. Any other questions?
Yeah,
Sorry.
Is there anything about how many rental application fees a company can collect? So if they post a
That's a great
and
question.
they collect 100 rental
So,
application fees?
and here's, I don't know, because they may be collecting the that company may be collecting the application fees, but I'm not sure what their agreements are with the property owner as for the tenants. So I'm not sure, one place may have different credit requirements or something like that. But I don't know, because as I'm saying that, I'm hearing myself say this and thinking, well, if you rate the credit score once, you have the credit score a second time as well. So the answer is I don't know. I'm not.
No, I'm saying that if they put a list of property and they get 5 applications and they already know they're renting, but they keep it listed and keep collecting applications.
How would you know?
Yeah, how would you know? Because
That's like that. Well, that's my first question is how do you prove it?
Yeah.
So sometimes and there's
Well,
a
if you
cliche.
know somebody,
It's not what you know; it's what you can prove.
okay, so if somebody says, I already got that place. And you apply for it 10 days after I already signed the lease.
Well, there is documentation there.
That may just be outside of kind of specific the rental application fairness act and just kind of be generally deceptive practices.
Well, there's a lot of that going on in the city. So anyway, the other question is about utilities. So if you're renting in a building that has multiple units and you get a bill with your rent that just throws in utility fees and you have no way of checking. So they can charge you whatever amount they want for each unit. How do you go about checking that?
I would need to look at your lease. I don't. There is no. This is why I can't answer like the more specific questions. Is how do I go about addressing that? I start to investigate.
Yeah.
What do you start to investigate? Start with your lease. Look at the meter. Find maybe the utility servicer. Maybe
Yeah.
try to subpoena their records.
She said she won't respond because
And now
you're
we've
not the
got
one
too
paying the
specific.
bill. Okay, anyway, this is student housing, it's not me.
That's okay.
It's
If they got a question, they can always
housing
give us a call.
Lots of young people are being charged like $100 each in a 4-unit little.
They're doing like a shared meter reading type thing, or they're claiming that
That's
they're doing shared.
$400 for a little.
I don't know about you, but I have massive power bills this winter. I'm not saying that what they're being charged is proper, but if they have concerns about that, I see you have our packet in front of it. You can give them CLS's contact information. Yes, sir.
Ernie, your opening comments about denial to applicants and letting them know why. 20, 30, 40 applicants per property in one day. Do we have to send, is denial the same thing as not selected?
Because you didn't select it, so we're in a binary choice here.
Yeah.
Approve, deny. So if you got 40 applications, you got 39 denial letters to write.
Okay. Do we have to write them? And I understand if we're requested to. If we request it, we have to write it. I understand that. If there's no request for denial letter or denial reason.
That's not a request, that's a shall.
Okay.
Yeah, no, the denial letter is a shall. That does not have to be requested. But like we talked about earlier, it's good faith efforts to provide that within 20 calendar days.
Yeah.
If you don't have contact information for folks, what are you supposed to do? Right? But if you've got an email address, you can send out the email, send it to an email address. Because I would say that's, you took the information that you had available to you and you did what you could to get that denial letter to the applicant. But you got a lot of applicants. Congrats on the desirable property. You got a lot of thank you, but sorry notes to write after the fact.
So that's a satisfactory response. Thank you, but sorry.
No, that's not satisfactory. It's fine. You have to state the specific reasons for denial of the application.
We didn't like you.
I'd be careful with that. If you write we didn't like you, I would really want that person to contact me next. Right? But I think we are getting a curtain call for this evening. I want to thank everybody so much for appearing online. Thank y'all. And thank you so much for taking the time out of your lives tonight to come in.
Thank you, Independent Center, for hosting.
Yes, thank you for hosting us.
And please answer the survey when we send it out to you.
Thank you.
And we can make you even better. Have a great evening, everyone.